Hello guys, and welcome to another episode of my lecture. On today's episode, we would be discussing the topic who can make admissions in court. Now, in my last episode, I discussed without prejudice admission, and we came to a resolution that based on the authority of section 26, without prejudice admission, that means admissions that are made while the parties are trying to foster the settlement of a dispute would not be admissible in court. And also, the class before then, I talked about admissions in previous proceedings by a party, and based on the authority of Awoke versus Owoduni, we came to the conclusion that admissions in previous proceedings are admissible in court. Now, today we'll be talking about who can make admissions. There are four categories of people that can make admissions in court. The first category would be between the parties. I think that this is pretty obvious. So we have A and B. A can make admissions in court, B can make admissions in court. That's what number one is telling us. Parties to a suit, A and B, both of them can make admissions in court. Number two, agents, servants, and persons with special relationship with the party. Now, in this case, we are talking about the agent of the party. And if you've done commercial transaction in your year 3, then you know who an agent is. Now, when an agent does something within his work permit, then whatever he does, if he admits to doing that thing, he can make admissions on that thing on behalf of his boss. So we have both agents, servants can make admissions on behalf of a party to a suit. Now, admissions can be made in a personal or representative capacity. So we have, for example, a community. If a community is being sued, or for example, the kind of example that I gave in my last class, where I said we have Shell versus a community in Delta State. So the suit is going to be, for example, we have the Ughelli people of Delta State. So we have Ughelli versus Shell. Do you understand? But now in that particular case, Ughelli versus Shell, one person would have to, represent the people of Ughelli versus Shell. Do you understand? It can't be all the people of Ughelli attending court meetings all the time. No. Or somebody who the village head has, delegated that particular duty to, that would represent the people of Ughelli. So where there are admissions made by that person in that particular court suits, then that admission cannot be in the personal capacity of the head of Ughelli or the delegated person that has been sent to represent the people of Ughelli. Do you understand? That particular admission is for the whole people because he said it in the representative capacity and not in the personal capacity. Do you understand? So admissions can be made both in personal capacity or in representative capacity, and I've been able to paint examples where we can have admissions in representative capacity. And then the last one is when an agent acts within the scope of authority. Such an agent can make admission which will bind the principal. I think I'd already said that in my number 2, where I told you that where you have an agent, then that particular person can, if he is acting in the scope of his authority, if he is acting based on the job that he has been given, then that agent, if he says something or he does something on behalf of the principal while he was doing his work, then yes, that thing that he has said can be admitted as evidence. Do you understand? Not evidence against him only, but evidence also against the principal. Do you understand? So in my next class, I'll be interrogating cases on this particular subject matter. We'll talk more about these things and have a more in-depth knowledge on them. I will see you in my next class.